you know, it's interesting. We've known each other a little while, and I don't think either one of us could have imagined the state of lawlessness that exists in America today. And I mean both on the public and private level.
Well, on the public level, we have governors who have enacted as if they were law, nothing more than recommendations, but they have used the power of the police to enforce these recommendations as if they were law. That, of course, implicates a number of violations. It's a violation of the separation of powers because it has what purports to be a law written by the executive branch, which is the governor. That violates the guarantee clause of the Constitution, which guarantees a Republican lowercase r form of government, meaning laws are only written by a representative body in all states but one, a bicameral legislature. It also violates the First Amendment because it restrains your ability to move, your ability to assemble, your ability to worship, and it violates due process in the 14th Amendment because it is taking away liberty without a trial and without proving fault. So the governors on their own, not the president, not the Congress, the 50 state governors and many mayors of large cities have on their own caused catastrophic damage to human liberty and prosperity. Flip side of that, of course, is that those in the streets who initially were expressing a political view in a peaceful way, lamenting a horrific torture and murder and complaining about police excess and brutality, well known, well documented, and essentially unchecked for 100 years, suddenly have been motivated to commit violence on their own. So the same governors that told people they couldn't assemble, initially praised the assemblies, now have to use the police to resist those assemblies. The president, of course, has added to this by using extreme force to clear Lafayette Park so that he could walk from the White House to a church for a photo op stunt, which is a serious violation of the civil liberties of those who were peaceably assembled in the park. So we have a mess. We have anarchy and tyranny at the same time. And theoretically, we still have a constitution, but very few people, very few of these cases have gone to the courts, and very few people in power are acting as if we still have a constitution.
So let's start with the governors. At least ostensibly, where do governors and mayors presumably derive their authority to shut things down, to institute business lockdowns, curfews, social distancing, all of these rules? Where would they tell you, Judge, that their authority to issue these orders without a legislature come from?
Well, their authority comes from the power of a gun, which the police carry, but they wouldn't tell you that. So the answer to your question is they would tell you, or us, that the powers reserved to the states under the 10th Amendment, which the Supreme Court has said is the power to regulate for health, safety, welfare, and morality, includes the power to keep the public safe. They would also tell you that most state legislatures have enacted emergency statutes that basically let governors do what they want in order to address an emergency. But no legislature can do the following. No legislature can transfer to the governor the ability to write law, because that would violate the guarantee clause of the Constitution, which says only legislatures can enact law. And no legislature can enact any law on its own that violates the Bill of Rights, because with the exception of the amount of bail, all aspects of the Bill of Rights are now applicable to the states. So if a state legislature of New Jersey, for example, said to Governor Murphy, here, you have the authority to write whatever rules you want, violates the guarantee clause. If they said to Governor Murphy, okay, you have the authority to shut the state down and lock everybody else up in their homes, that violates the provisions of the Constitution that I addressed earlier. Freedom of assembly, freedom of worship, freedom to travel. So even though the governors will make these arguments, they are very flimsy.
So when it comes to some of the government actions we've seen over the last couple of months, whether it's a business closure or a quarantine measure for COVID, whether it's a curfew or a stand-down measure for the recent civil unrest, where does due process in the Constitution comes in. I mean, you've written about how there needs to be a level of specificity with respect to the harm, with respect to the actors, and some ability to respond in, either in a tribunal or at least a regulatory hearing. So we don't seem to see any of this specificity or due process happening. We seem to see just sort of blanket decisions by governors or mayors and no due process whatsoever.
The majority view, lamentably, is that when the government wants to infringe upon a fundamental liberty to be defined in a moment, the government can do so if it can pass the strict scrutiny test. And strict scrutiny requires that the government is serving a compelling state interest, and it is doing so by the least restrictive alternative. So I would argue, before we even get to the minority view, that the governors aren't even able to pass this majority big government version of due process, because quarantining the healthy is hardly the least restrictive alternative to prevent the spread of the disease. Now, the minority view. The minority view is that our rights come from our humanity, and the government can only interfere with those rights when we have interfered with somebody else's right. That is the literal due process, meaning the government would have to hold a trial and prove fault before it could deprive anybody of due process. The Chief Justice John Roberts does not accept the minority view. He accepts the majority view. He said so as recently as earlier this week. Back to what is a fundamental liberty. The Supreme Court, in recent years, I'd say the past 20 or 30 years, has preferred not to call liberties fundamental. It's preferred to call them substantive. So substantive due process is a fancy phrase for natural right, fundamental liberty. To the big government folks, it's liberties that are expressly articulated in the Bill of Rights. To those who believe that our rights come from our humanity, it's the rights that you had in nature. It's your natural rights. The government cannot interfere with any of those absent due process.
Well, so here's the devil's advocate argument, even within the state. You look at a governor and say, well, there's a pandemic and it can spread very quickly, and I don't have the ability to bring specific people before a court of law and specify the level of harm and apply the strict scrutiny rule. I just have to issue an order because it's just not practical in mass to provide due process to the whole citizenry, let's say, of a state.
Well, then that governor is not taking seriously his or her oath to uphold the Constitution, because the Constitution could not be clearer. The concept of a civil commitment, you will stay home and not come out of your house without any fault, has been condemned since the days of Magna Carta in the 13th century. There is simply no articulable basis consistent with Western values, much less consistent with the Constitution. Now, I've written extensively about the Ninth Amendment. This was a point of pride for James Madison. The Ninth Amendment basically says just because we've enumerated rights in the first 8 does not mean that there aren't other rights retained by the people. We all know that it would be impossible to list all the rights the people have. So the Ninth Amendment is the natural law embedded into the Constitution. So your right to go out of your house and your right to buy a newspaper, even though not expressly articulated in the first 8, is clearly protected under the Ninth.
Well, what about governors, though? Give us, at least hypothetically, what's a cause of action somebody might bring against some of these state governors, which I would like to see for their COVID shutdowns. I'd love to see that happen. Is that pie in the sky?
The one that reached the Supreme Court 2 days ago, they actually released their opinion. I don't know how they did this. They released their opinion at 3:48 in the morning. And that was against Governor Gavin Newsom in California over the opening of churches. So Governor Newsom ordered that houses of worship in California can open, but they can only hold 25% of their normal capacity or 100 people, whichever is less. There are 2 cathedrals in California that hold 3,000 people. And so the argument was this is arbitrary, capricious, unreasonable, and discriminatory. You're allowing 150 people in Walmart. You're allowing 100 people in ShopRite. You're allowing 50 people in a Mercedes-Benz dealership, and you won't allow 50% of the people to sit in a church. And the Supreme
Right.
Court Chief Justice Roberts, siding with the four liberal members of the court, basically said, it's a health pandemic. He can do what he wants as long as it's not permanent. Oh, that's terrible, horrific jurisprudence. It's a suit against a governor based upon an expressly guaranteed constitutional, fundamental, substantive, natural right, the free exercise of religion. And the court thumbed its nose at that charge. I fear the worst. I fear that nobody takes the Constitution seriously. Not the president, not Congress, not governors, not state legislatures, not federal judges, not state judges, with some exceptions. I mean, taxes are going to go up, regulation is going to go up, life is going to become less bearable and less free, in my view, unless, as Jefferson said, and I don't mean this literally, the blood of patriots should be spilled on the tree of revolution at least once in every generation.